Be seated. All right, we have one final case for the day, and somewhere I have its name. Mr. Carlisle, tell me what it's called.
Yes, Your Honor. It is.
There, never mind, I've got it. I'll do my job. Bautista versus SOUTHMOST Drywall.
Thank you very much. May it please the Court. Good morning. My name is Chris Carlisle, and as Judge Griffin just mentioned, I represent the appellant in this case, YESSICA Bautista, who's personal representative of the estate of Jose Bautista. I'd like to reserve 5 minutes for rebuttal if I could. Your Honors, this case presents one issue to this Court, and that is whether or not summary judgment was appropriately granted below. The issue is whether or not there was sufficient evidence brought forth at the trial court to have the issue of gross negligence go to a jury. We all recognize that's a high standard, but it's not an impossible standard. I think the critical inquiry is, if not in this case, then in what case? We have the Cabrera case out of the third from 4 years ago, which is remarkably similar, where they reversed summary judgment under remarkably similar circumstances. And by similar circumstances, I mean we have two expert affidavits that were offered in this case and that were extremely detailed, offered by extremely qualified experts that analyzed the facts, read the depositions, and came to the conclusions that would support gross negligence, similar to what you had in Cabrera. In Cabrera, you have the court saying they didn't train these people. Here we have evidence they didn't train the people. We have in Cabrera saying they didn't have a safety plan in place. Here there's evidence there was no safety plan in place. Critically also, we have the OSHA violation, which was noted in Cabrera as being a serious violation, which is what we have here, and providing another reason that summary judgment should not have been granted. A serious OSHA violation is one that recognizes there was a substantial probability that death or serious physical harm would occur as a result of this violation. A substantial probability of death or serious physical harm. So what do we have here? We have the OSHA violation saying they didn't train the people appropriately. These guys, the operator was obviously not trained at all. There's no dispute about that. He's operating a boom 100 feet in the air.
When you say he wasn't trained at all, he wasn't formally trained.
Wasn't formally
He didn't go to
trained.
school.
He didn't take any course.
But he was apparently worked with someone else on the job for 6 weeks and then operated this crane or boom for 6 weeks with one minor scrape, apparently. It wasn't like it was the first time he'd gotten up on the thing and started playing around.
It wasn't his first day in the boom. However, it was undisputed. B&B, candidly acknowledges that he had no certificate. Again, one of the things that needs to be considered in this case was we're talking about a complicated system and a complicated job site. And to downplay what is required to operate a lift 100 feet in the air in the context of what was going on here, I think is a bit disingenuous. When you have multiple lifts operating, you have an untrained operator. He had on-the-job training, if you want to call it that, get in the lift and learn how to do it. But when you have federal standards that say that training should have been given here, and it was inadequate, and the lack of that training resulted in a substantial certainty of death or serious injury, I don't think you can downplay it and say, gosh, you know what, it wasn't really that complicated. He didn't really need to be formally trained. He didn't need to have any sort of classes or formal training, and it's really not that big a deal. Well, it is a big deal. OSHA found it to be a big deal. Cabrera, the third DCA, found it to be a big deal. Simply put, I mean, we pointed to three different categories of evidence. The affidavits, which I think are absolutely critical, and I think in and of themselves should have been sufficient to survive summary judgment in this case. Then you throw in the OSHA violation, substantial certainty of death. Then you throw in all the factual issues that we have recognized and have cited to. Again, B&B was pretty candid in their brief. They say there was obviously conflicting evidence below about who in fact was supervising this guy. And therefore, for the purposes of summary judgment, they recognize that it was a factual issue. They recognize he had no certificate. They recognize that they had no formal written safety plan in place. They recognize, as they must, that according to the conflicting evidence, there were not cones or tape around the area in place.
Let me ask you this, Mr. Carlisle. Was the evidence undisputed that this lift operator knew that he wasn't supposed to be operating it if there were people directly below?
There was so much evidence that I'm trying to recall, and I've sifted through it, believe me, over the last few days, so I'm trying to recall all the specific evidence. I think you're saying that did he know that he was not supposed to operate it? I believe so, and I will look and try to find a citation.
Well, assuming that he knew he wasn't supposed to do it, was the evidence also undisputed that he did not know someone was beneath him?
I think that there was evidence that they said, but let me back up. There was evidence that they didn't look, that they knew there were people around, but at the precise moment, I didn't look down and see them directly below me. I believe is a fair characterization of the testimony. They knew, and he said that morning there were 3 or 4 other lifts operating in the area. And he also said, and his mate on the lift said, at the precise moment, we didn't look down and know they were there. But the question is, should they have known, should they have marked the area below, knowing that there were lifts that could conceivably have been beneath them at the exact moment?
We're just trying to determine whether there's sufficient evidence to support gross negligence versus negligence. Would you agree it'd be different if you had someone up there who knew he shouldn't be operating the equipment, there's someone below him, knew there was someone below him, but said, I'm a good enough operator, I can do it anyway, versus someone who knows they shouldn't operate it, does not know someone is beneath them, and maybe that's due to the lack of a safety plan, or maybe that's due to lack of training. But would you agree there is a difference there on
I would think there is a difference there, and again, I think if you look at what OSHA found in this case, they said there were 2 things, and one was that they did not train him to recognize the dangers of operating the lift at 95 feet in the air, and they didn't tell them not to work above others. They weren't sufficiently trained and given instruction about operating the lift under those circumstances. So if you had an experienced lift operator who had gone through the course, who there was no doubt they knew certain things here, this would be a different case. But what we have is knowledge on behalf of either B&B or SOUTHMOST that these guys, and B&B said, if we would have known that they were asking us to have lift operators, we never would have given them these workers. SOUTHMOST then says, well, gosh, our contract says they were supposed to give us experienced people, and that's their fault, and so we're kind of getting a finger-pointing deal. But the reality is, the experts say, OSHA says, they were not trained appropriately. There's a substantial probability of death or serious injury given the circumstances that were there that day. And again, the cases say you look at the composite of circumstances that are going on. And the evidence here was multiple lifts, no tape below, inexperienced, relatively inexperienced, some experience, but untrained operators of these lifts. Ultimately, a jury might say, we're not buying it. It doesn't get to the level of gross negligence. But the question is, if not in this case, what case? What case when you have the OSHA violation? What case when you have the expert affidavits saying, here's the litany of circumstances that led to this. Given all these things coming together on that day, it's our opinion that these standards were met. I'll address briefly the expert affidavits and also the OSHA report. We pointed out in our briefs that, again, I think that if those are considered, which they have to be, summary judgment clearly should not have been granted. There's sort of an 11th hour attempt to discredit the affidavits or the OSHA reports that were not raised below. The only thing that was ever said below about these things, perhaps in recognition that they were appropriate, was, gosh, you can't just file an affidavit and workers' comp would be destroyed. Well, the reality is expert affidavits were appropriate in this case. You have specialized situation going on here. You have the evidence code saying that experts are allowed to provide testimony concerning and to assist the trier of fact in determining factual issues. You have 90.703 that says they can render an opinion on the ultimate issue in a case. We're hearing these affidavits now are conclusory. They're far from conclusory. Mr. Fisher's affidavit is 10 pages long, going through fact after fact after fact and the circumstances getting here. So, again, I think that the attempt on appeal to argue that the affidavits were somehow inappropriate certainly falls or fails. The OSHA report, we're hearing again for the first time on appeal that somehow they're hearsay. There's no authority given for that. 90.8038 deals with public records and reports. And again, one of the cases that is cited by B&B, the Florida Supreme Court recognized that provision in the evidence code and said that the conclusions found in certain reports are admissible, but kept out some factual determinations that were there. So again, just as in Cabrera, we have experts that were qualified, that were given extensive affidavit testimony about the circumstances. We have OSHA violations, and we have extensive discovery with conflicting issues that had to be resolved in our favor about the lack of training, about the dangerous situation, about who knew what. Again, Your Honors, barring any other questions at this time, I'll save the remainder for rebuttal. Thank you very much.
Thank you, Counsel.
Good morning. Pleases the court. Bill Bissett, representing the appellee SOUTHMOST DRYWALL. Excuse me. Along with me is Yates Rumbley, and at about 10 minutes I'll turn the ball over to him. I had quite a bit prepared, but I think the court has hit on some of the key aspects of this case from a factual standpoint, and I'll try to address those. I think it's very important, though, for there to be a little summary of the key cases on both sides of the issues, and Mr. Rumbley will pick that up, hopefully.
Let me ask you, in reviewing this case, do we have to assume that the operator was not sufficiently trained?
Absolutely not. In fact, the record is...
Is there a factual dispute on that?
There's no factual dispute whatsoever. The testimony, there are two areas of testimony which we go through quite extensively in our answer brief, and it's not brought back up in the reply brief and vaguely touched upon in the
Can we assume as a matter of law that someone who has no formal training but has 6 weeks of experience is adequately trained? I mean, can we do that as a matter of law, or is that a factual issue to be resolved by a trier of fact?
No, in terms of attempting to determine whether there's a level of conduct here to rise to gross negligence, you look at what the facts are, and this gentleman had been on the lift for 6 weeks observing and being trained, and that's all. If you look at the OSHA regulation, which we set out, it just says before you work on a scaffold, and this qualifies as a scaffold, I assume, you must be trained, and that's all it says. So we fill in the blanks here, and out in the field, the gentleman was on it for 6 weeks observing, learning how to operate it. He then operated this lift and various other lifts for 6 weeks, not a single complaint, nobody, there was no incidents, there were no close calls, nothing. This particular accident was an unfortunate situation where this lift dropped about an inch, made contact, totally unknown to the individual, with a piece of facade that was hollow concrete or decorative concrete, which was only able to support its own weight, and it broke off. Even the most qualified individual most likely would not have been able to avoid that situation. The second area was the gentleman from H&E, I believe was the company that leased this boom and brought it to the construction site, and he was asked about the only thing they're complaining and can complain about is Mr. Arazin, we admit, did not have a certificate. Well, to get the certificate, the gentleman from H&E said it could be anywhere from a half an hour to several hours, and the maximum, the longest one he's ever heard, is lasted a day. The gentleman, and we quoted his testimony, that he learned within an hour very easily and quickly, along with the owner's manual. This Kleber Arazi had been operating this thing, certainly knew how to operate it, for doing it for 6 weeks with no incident.
How do you address the argument that as it relates to the affidavits or the OSHA violations, that any objections that you have are waived because they weren't specifically made below?
Well, the objection that was presented to the judge was to the effect that if all it takes is to come forward with an affidavit, which the critical parts that they quote are strictly the buzzwords from Chapter 440.11, the immunity provision, if that's all it takes, then you might as well throw out workers' comp immunity, because every single case, we'll have an expert saying that there was a clear and present danger, imminent danger, conscious disregard, and those were the buzzwords that they used. Let's look at the facts. They want to avoid the facts.
But in your answer brief, you raised the objection that it's hearsay.
I don't believe it specifically they raised the argument that it was hearsay.
So is it appropriate for us to consider it?
Well, if it constitutes hearsay, it's incompetent evidence. And as a prevailing party...
The reason, like if you had made the objection below, maybe they would have gotten an affidavit from the OSHA inspector, but if you don't object to it, why shouldn't we consider it? I mean, your other arguments still may have merit, the ones you're making that the fact that there's an OSHA violation doesn't mean they win. I mean, I understand that, but as far as to give consideration to it, you don't raise hearsay below. If you had, they may have been able to correct it. Now you raise hearsay here. I mean, why isn't that waived?
Well, I don't think in the face of the actual facts, uncontradicted facts as to how the accident occurred and who knew what, relating directly to the accident, that the OSHA citation can overwhelm that. I mean, typically the waiver...
But as to the hearsay objection raised in your answer and not raised below, do you believe that's waived? And if not, why not?
Well, it's usually when a party attempts to seek a reversal on the basis of a grounds, in the case they cite, is just that situation. They try to seek a reversal in the appellate court on an argument or a ground that was not raised specifically in the trial court. The shoes on the other foot here, we're entitled to argue based on the record, and the record that's before this court, that it's hearsay on its face. It was unauthenticated as far as I can tell. And the OSHA citation, I do not believe would even be admissible, just like traffic accident and who was charged, unless they actually pled guilty, would not be admissible either. And you can only consider competent evidence for either in support of or in opposition to summary judgment. I think the critical facts also, and carrying through, Judge Cohen asked earlier about did Eraza know that you were not supposed to lift your boom and operate directly above other people. He testified that he knew that. He had been trained that. They had toolbox meetings, and in the record, I think one of those toolbox meetings covered safety with boom lifts, and even on the building, check to make, if you're working on the top of the building, you make sure that there's not somebody directly below. Which ties in on a little sidetrack. One of the areas they claim constitutes the totality of the circumstances was that the area down below around this particular lift was not marked with cones or protective tape. There was apparently some factual dispute on that. It's actually irrelevant when you look at how the incident occurred. The boom, and it's uncontradicted, the base of the boom that the decedent was on was not directly below. It was farther down, and attached to our brief is a elevation drawing, and you can see the A and the B points that were marked, so it gives you an idea of the configuration. Our boom is working up this way, and their boom is over here doing back and forth, back and forth, and back and forth. And they actually at some point moved. I don't know if it was directly underneath, but certainly in hindsight, close enough underneath that either this concrete bounced off something else, but eventually hit their boom lift. The second part of the question, did he know, did the people all three people that survived this incident, the two in the upper boom and the survivor that was with the decedent in the lower boom, they all testified that they didn't see anybody above and we didn't see anybody below when this happened. So I don't know how you can meet the element of conscious disregard as to anybody separate and apart from the three people who you can't establish knowledge of an imminent danger, conscious disregard of that danger. That was not a contributing cause, but the major contributing cause of this event. And I think the final question was asked of Mr. Carlisle, that if in fact Mr. Eraza had known that somebody was working down below him, and he says, well, I'm not stopping. I'm going to go ahead and keep working, and if I hit something or if we drop a hammer or a tool off, it's too bad. That would be a totally different situation. That is absolutely not what we had going on here. And in fact, I think Mr. Eraza, we had set out a portion of his testimony, I believe it may be in one of the footnotes, that he said, certainly if I had known that they had moved down below where we were working, I would have stopped what I was doing and would have yelled down to them to move. We touched on the federal requirement, so we have no certificate. In this case, it's totally irrelevant. Wouldn't have changed the outcome of this particular incident. Nothing would have, there's no, other than pure speculation, there's no reason to say anything would have been done any differently. They talked about marking the area. We've gone through that. And also with respect to the marking of that area, Mr. Corcoran, who was the individual that was in the boom along with the decedent, he testified that he knew that they were working up above him in that area. So having the tape and the cones around the base would not have made any difference. I think, and there's no evidence, regardless of the parroting in those affidavits of the two experts, just parroting the buzzwords that support what they're saying. There was no evidence of conscious disregard that was the major contributing cause. There was no chargeable knowledge. We set out what the testimony was, and they don't touch it in their reply brief. Compare my answer brief along with their reply brief, and they stay off of that. They instead want to look at the affidavits. And several of the cases, which at this point I'll let co-counsel, because the cases really tell the difference, starting with the Cabrera. Their Cabrera case actually shows where you need to go to get the type of testimony. And at this point, Yates, I'll turn. I believe you need to affirm, at least on behalf of my client, and for actually all the appellees in the case. Thank you.
Thank you, counsel.
May it please the court, I'm Yates Rombley. I represent the other appellees, which is B&B and their two employees who were working in the upper boom at the time of this accident. Let me touch quickly on a couple of points that have already been discussed, and that is the expert affidavits and the OSHA citation. First of all, those are not issues that are waived in the situation we have here, in my view at least. If we were seeking to overturn the lower court order based on points that had not been argued, then we would have a problem. But we are not seeking to overturn the summary judgments. We are seeking to have them affirmed.
Oh, but the issue for me is if there was no objection below, their argument is that we're entitled to look and consider the affidavits in their totality and the OSHA violation in its totality to determine whether there's an issue of fact or not.
And I think that's just simply incorrect.
And why is that?
I think it's Hornbook law that matters in the record to be considered by the trial court on a summary judgment have to be admissible evidence.
Well, isn't it admissible if the judge says, anybody have any objection, and nobody says no?
But, Your Honor, this was not a trial where evidence is proffered and you object and it's either admitted or not.
Oh, but you file a motion to strike, you file I object to the consideration of this. I mean, you've done it before.
You could, but I think it's pretty clear that even if the trial court got it right for the wrong reason, it still should be affirmed. And if the trial court...
Got no problem with, you still may have a winner, I don't know. But what I'm suggesting to you is that if you don't object to their affidavits, I think we all agree that there's a lot of their affidavits that are fine. It's some of the application of legal standards to facts set forth that is perhaps questionable. But that was never argued to the trial judge. The admissibility of the OSHA violation was never said, Judge, you can't consider this because of this case out of the Florida Supreme Court. So what's the judge supposed to do, object?
Well, he got it right. And that's my point. And I think this court can consider whether the trial court got it right. And these inadmissible affidavits and an inadmissible OSHA violation should not be a basis for what this court considers here on this appeal. And I think it's pretty clear that those ultimate opinions in the OSHA violation and in the affidavits are clearly inadmissible testimony.
Well, why weren't they inadmissible? I mean, why didn't somebody, I don't know if you were at the hearing or who was at the hearing, but...
I was at the hearing on my motion.
How come you didn't make that argument to the trial judge? It's a good argument. How come you didn't make it below?
Well, I guess the short answer to that is I didn't need to. The court reached the right decision based on the arguments that were made. And an additional reason why that decision was correct is that the affidavits and the OSHA violation should not properly have been considered in any event. And I think that's another reason to affirm the trial court's decision. Let me very quickly talk about the case law, because we really haven't talked about that yet, and I think it's important. There are a number of cases that are cited in which summary judgments for the defense have been affirmed, in which denial of summary judgment has been reversed. And I think those cases tell us a lot about what is not gross negligence. We had the Weller case, which is a case out of this court. This was the case where a fellow was standing in front of a truck when another guy cranks it up without checking the brakes and the gear, and it turns out it was in gear and the brake was not engaged, and the fellow gets crunched on the front of the truck. This is a situation exactly like what we've got in this case, where somebody's involved in an activity that's potentially dangerous. They know there's somebody in the line of fire, and they screwed up. Somebody got hurt. It's negligence, but it's not gross negligence. There has to be more than that. The Merriman case out of the 2nd DCA is the same thing. This was the one where the defective crane was being used to lift a load over somebody below. There was a known mechanical defect in this crane. Not only did they know there was a mechanical defect, the crane had already dropped a load previously, and sure enough, it drops a load again on the guy that's underneath. You've got a potentially dangerous activity. You've got somebody known to be in the line of fire who gets hurt. It's got to be something more than that. The Klein case out of the 3rd DCA, this was the meat tenderizing machine. You know you've got employees that are using this machine. You know it's not bolted down. You've taken off all of the warnings and the cover on the machine. You've disabled the emergency cutoff on the machine. So you've got a situation that has knowingly been created, knowing that there are people in the line of fire, so to speak. Somebody gets hurt, still not gross negligence. There's got to be something more. Fleetwood Holmes case, also out of the 2nd. This was the forklift that was being operated in such a narrow corridor that they actually had to lift the load up so that it blocked the load, the view of the operator, because the aisle got wider as it went higher. The operator sees somebody in front of the forklift, beeps the horn, and knows that the guy doesn't get out of the way, has no view, inches of clearance, unsecured load, sure enough, bump something, the load falls on the fellow. Again, you've got this potentially dangerous activity going on, knowing that somebody's in a position where they're at risk. Got to be something more. And the something more is in the cases that actually are cited by the appellant in this case. The Greathead case, this was the case where the fellow was standing on the platform of a wood chipper machine that was being towed down a dirt road at 35 miles an hour, hanging on with one hand, waving, and falls off. And in that case, the driver of the truck was actually charged with vehicular homicide and ended up pleading guilty, charged with manslaughter and vehicular homicide, and pled guilty to vehicular homicide. So I think you've got a much more egregious situation there where what is actually going on is virtually certain to result in somebody getting hurt. In our case here, even though there was a potentially dangerous situation with one boom higher than the other, if everything had gone according to plan, nothing would have happened. You tow somebody on the back of a chipper down a dirt road at 35 miles per hour, virtually certain bad things are going to occur. That's the difference. The Sullivan case, this was the bank manager that was shot during a robbery. It's quite a different factual situation, but pretty egregious. This was one where the bank removed the guard just to save money. And then within 8 months after removing the guard from the bank, there's actually 2 bank robberies occur in which the robber threatens to kill the bank manager. They still don't do anything. The robber comes back and kills the bank manager just like he said he was going to do.
Mr. Rumley, you're out of time.
I think we've got a vastly different situation in this case from the cases in which the courts have found gross negligence, and it should be affirmed. Thank you.
Thank you, counsel.
Your Honors, Judge Evander asked the question, don't we have to accept for the purposes of this appeal on summary judgment that he was not sufficiently trained? I was rather surprised to hear the other side say no, and then proceed to make what is essentially a closing argument about the conflicting factual issues and whether or not training was actually required in this case. You have OSHA finding that the lack of training created a substantial probability of death or serious physical harm. You have affidavits from experts saying the relevant safety standards and lease provisions dictate that AWP lift operators are required to be trained and qualified, including with regard to foreseeable dangers involved in all lift equipment. Without such training, injury is likely to occur. Mr. Fisher, the lack of training and qualifications under the circumstances this state of the incident constitute an outrageous deviation from the standards for safety and demonstrate a reckless disregard for the lives of others. Yes, you have to accept that he was insufficiently trained, and the insufficient training led to the accident here. We're hearing on the 11th hour about OSHA, the OSHA document, and about the affidavits, because if those are in the record, which they were properly, then they lose. They create significant factual issues which are insufficient, just as found in Cabrera, to justify granting summary judgment. We're hearing the OSHA document as hearsay for the first time. Nothing in either brief provides any authority for that. Nothing. There are 2 cases cited, one from Georgia and one from the Florida Supreme Court, that are clearly distinguishable. Furthermore, again, according to the Florida Supreme Court case they cite, 90.8038 public records and reports are an exception to hearsay. The OSHA documents clearly were relevant. They were considered in Cabrera. We cited another case where OSHA documents went to the issue of negligence. And finally, Fleetwood, where Judge Altenburn wrote that extensive decision that they just talked to you about. The lack of an OSHA violation was cited by Judge Altenburn in that case as justifying the decision that the court ultimately made. There's no authority whatsoever in the state of Florida for suggesting that OSHA documents are hearsay, and indeed they've been relied on in cases exactly like this on numerous occasions. The affidavits. Judge Orfinger, you again asked some questions about this, and I think it's critical to talk about what is acceptable and what is not as far as these affidavits go. Again, the relevant provisions we're talking about are 90.702 and 703. Lay witnesses and experts can't offer opinion testimony that goes to the ultimate issue. We know that. The one thing that's prohibited is when you are operating legal standards and doing this and offering an opinion that rises to that. If you look at the notes to 90.703, again, and the case law on this talks about a fine line or a fine distinction here in a matter of semantics. I can't come in and say, was this gross negligence, and ask my expert that. I can ask my expert, did this deviate from the standard of care, and then argue to the jury a deviation from the standard of care is gross negligence. There is no indication in these affidavits that there's no improper legal conclusion that was reached where these experts said this was gross negligence. They did say that, yes, according to our opinions, it deviated from the standard of care, and the testimony was there that rose to that. The reason that such expert testimony is excluded is because it has the potential to confuse the jury. Here we're talking a summary judgment context. We're talking about the court looking at these affidavits, and maybe somewhere when this gets to the jury, they can fight about what these experts are allowed to say and what they're not. But these were not conclusory. They did not semantically say this was gross negligence. They said we think they deviated from the standard of care, and here's why. They were clearly appropriate, and they should have been considered by the court. Finally, the case law. Again, these cases are all very factually distinct and very factually complicated. But I think that by any fair reading of these cases, the most substantially similar case is Cabrera, where you have the OSHA violation, you have two expert affidavits, you have a failure to train, you have a failure to provide warnings in the area. And so, again, they're all decided on their own merits, and there are factual distinctions in these cases, but Cabrera, I believe, is by far the most similar. And unless there's any other questions, Your Honors, I think that'll do it for me this morning.
Thank you very much.
Thank you very much.
That's our last case for the morning, so we'll be in recess until Thursday.
Thank you.